Good morning, everybody. I'm Simon Baigent, and I'm the National Head of Freeths Food Sector. I'm delighted that you are able to join us this morning for what will be a first of a series of webinars throughout 2024, focusing on developments that could impact your business in the food sector. At Freeths, we're all familiar with the challenges you face across the whole supply chain as we act for businesses from both the field to the fork. We offer a complete source of legal support to our clients, including specialist expertise, particularly in regulatory regimes, including food safety, health and safety, GSCOP, environmental, energy, competition, and of course, labour, which leads me on to the focus of today's webinar. Labour shortages in the food sector have been widely publicised and need no introduction. The impact can be severe and wide-ranging. Threats to food security, welfare of animals, mental health for those already in the sector, and of course, unharvested crops. As Ashley will be telling you, now more than ever, it is essential that you have the correct right to work checks in place at these challenging times. So Ashley, over to you.
Thank you so much, Simon, and good morning, everybody. Thank you for joining us. I'm really hope that today's session is going to leave you with a better understanding of the reasons and process of right to work checks. Next slide, please, Tom. Today, we're going to be going through the who's, the what's, the why's, the when's, the how's of right to work checks and legislation. And throughout the session, we're going to be discussing tricky scenarios that you might find yourself in, and how you can go about tackling those. And at the end of the session, we're going to go through questions that you might have. Please do send any questions that you've got throughout the session, and we'll go through them all. Some of you very kindly have already forwarded questions when you registered. There were a couple that I'll come back to you directly on, just because they were either out of scope of today's webinar, or I just need some further clarification. And we're going to just jump into it. Go next slide, please, Tom. There are several reasons why we conduct our right to work checks, and probably the most obvious reason being because it's the law. There has been right to work legislation in place in the UK since 1996, so it's not new law, but this is an area of law that does change regularly. And the legislation that I've got here on this slide is what's currently in effect. It is coming up to further changes in a few weeks' time, yet again. But the Home Office have very helpfully provided us with a series of guidance and codes of practice on how we can comply with these laws, these legislations, and they expect that we will comply with these guidances. You've got the Employer's Guide to Right to Work Checks that's currently in effect, that's currently dated 18th of October. That is due to change in February. And then you've also got the codes of practices on preventing illegal working and avoiding unlawful discrimination. Another reason why we're required to conduct the right to work checks is because employers have a responsibility to prevent illegal working. The Home Office tell us that the ability to illegal work is one of the main drivers of illegal migration to the UK. And, it does leave vulnerable people open to exploitation and to the abuse of unscrupulous employers. It undercuts compliant businesses. It leads to other labor market abuses like undercutting national minimum wage, tax evasion, breaches of other employment areas, and as well as exploitative working conditions, including modern slavery. It is also a criminal offense to knowingly hire somebody who doesn't have the right to work. This is just one thing to keep in mind. And I would say that the fourth and final reason, if you go to the next slide, please, Tom, and for us, as business owners and HR professionals, it protects our business. When we conduct a right to work check in the way that the Home Office have stated, then we acquire a statutory excuse. And what this means is that if it turns out we have hired somebody who doesn't have the right to work, then our business will be protected from the penalties. For the sake of right to work legislation, illegally working is not just someone who enters illegally and works off the books. It will also include people who have entered legally and possibly have overstayed their permission, or even those who are here legally working, but they've breached the conditions of their visa. All for all intents and purposes, that is considered illegal working in the UK. Next slide. Now, In order for us to acquire that statutory excuse, we have to conduct the check before employment starts. It can be done on the first day of employment, but it has to be the very first thing that's done. And if that person doesn't provide you with an acceptable proof of right to work, then you should not start employing, because you will not acquire that statutory excuse. It's not possible to retrospectively acquire a statutory excuse. So you're always going to be employing that person at risk to the business. And if that person has a time-limited statutory excuse, like they've got an expired visa coming up, then you'll need to conduct follow-up checks in order to maintain that statutory excuse. So the whole purpose of these checks is to acquire and to maintain that statutory excuse. With follow-up checks, you've got 28 days from the date that that expires to conduct those further checks in order to maintain that statutory excuse. Next slide, please, Tom. You, as the employer, are required to check everybody who's employed by you under a contract of employment or service or an apprenticeship. You are ultimately responsible for conducting the checks, even if you delegate these to a third party, and you are the one who will be penalized if they're not done correctly. And the Home Office guide, or the Home Office guidance, have been set out to ensure that if you conduct these checks on everybody, then you're going to be doing it in a way that's non-discriminatory. You're going to be not making any assumptions on the candidate or employee on the basis of their color, their nationality, their ethnicity, their national origins, their accent, their surname, or even the length of time that they've been in the UK. So it's not enough to say, well, that person seemed British, we were happy, you that would be discrimination. So you want to make sure that you're doing this on everybody. And this comes to our first tricky situation. It's, what do you do about people who aren't employed by the business, agency workers or contractors? You are not legally required to conduct the right to work checks on these workers, but there are compelling reasons why you should make checks or make inquiries to check that they do actually have a right to work for your business. If you've got an agency worker who is removed from your business, then it's you that's going to suffer the operational disruption. It's you that might suffer reputational damage because they were removed from your business. An example of this, which happened to a Sainsbury's, there was an agency workers who were working for them as cleaners. It turns out that they were put there illegally by a criminal gang. And even though the criminal gang is the one that was punished for it, it's Sainsbury's reputation who's gone through the mud, because they're the ones that have been connected to this illegal migration or illegal working. There's also voluntary workers. There is a very complex legal distinction between volunteering and voluntary work. But what you'll need to bear in mind is, if somebody has an obligation to conduct the work that you were obligated to offer, then you need to conduct those checks on them. It doesn't matter if they're not being rewarded for the work that they do, or it doesn't matter if they're being rewarded in a way other than money. You just want to make sure that they can conduct that voluntary work. Not everybody with visas have the right to work, and that does include working for free. Next slide, please. And as stated before, the Home Office have set out very clearly how we can conduct these right to work checks. And there are 3 different ways: the manual, online, and ID service provider. Now, I've put here a 4th way, the employer's checking service. But as you'll see momentarily, this is a check that sort of straddles manual and online right to work checks. But with all these type of checks, what you're going to be doing is obtaining something, you're going to be checking that something, and you're going to be retaining it on the employee's file. Now, if you have an employee that can provide you with an evidence of the right to work check through manual, you can't then dictate that they provide you a right to work check online. You can't mandate how they provide you a right to work check, as long as they're providing you with a correct evidence of right to work. And this is just to ensure that we're not discriminating unlawfully against a candidate or an employee. Next slide, please. With your manual right to work checks, you're going to be obtaining a physical document that's acceptable under the right to work legislation. You're going to be checking that document and retaining a copy of it for the file. The Home Office have set out 2 lists in the right to work guidance, List A and List B. List A provides us with a continuous statutory excuse. So this is your one and done. If you get this document, you don't need to check again. You will maintain that continuous statutory excuse. List B has a time-limited statutory excuse, and that's usually because they've got an expired visa coming up, or the document you've checked, it was due to expire, and you'll need to do follow-up checks in order to maintain that statutory excuse. Now, it's worth noting that the document to prove a right to work doesn't have to be photographic identification. So you won't see on these manual right to work checks, you won't see driver's license as an acceptable right to work check. You won't see a UK citizen's card. And that's because those are documents that don't convey a right to work. So if you're accepting those type of documents because you want to have like a photographic ID, then you won't be acquiring your statutory excuse. And we're gonna go to our first poll. If please, and it's just to see if you're still awake. And are we allowed to accept biometric residence permits from workers as a proof of a manual right to work check? And if you don't know what a biometric residence permit, it is a pink card that the Home Office issued to migrants as proof of their immigration status. So we're just going to give you a couple of moments to have a think about that. Okay, should we see the results for that? Oh, brilliant. Well, so most of you got that right. No, we can no longer accept biometric residence permits and haven't been able to since April 2022. And that's because the Home Office are moving to what's called a wholly digital immigration system. Can we get the next slide, please? And what you're going to see now from migrants who, if they offer you a biometric residence permit, you need to ask them to go online and get a share code. So you can do this, an online right to work check. And what you're obtaining in this case is a share code. You're going to go onto the gov.uk website, check the check, and then retain a copy for your files. They very helpfully provide a link where you can print off the page or you can download a PDF, so it's really easy to do. You need to obtain a share code that starts with W for work, because you won't acquire statutory excuse if you conduct a right to work check with a share code starting in R or S, because those are for other purposes, such as a right to rent. You'll notice as well that they no longer tell you what the immigration route is that the person is on. All it will tell you is how long they've got a right to work for, and any work conditions if they have. The Home Office have confirmed that they don't plan on providing information about the immigration route on these online right to work checks. They say it's a need to know basis and we don't need to know. Throughout 2024, they are doing away with biometric residence permits. And this is part of moving into their wholly digital immigration system. So you won't see biometric residence permits at all from 2025, as they will no longer be valid. The final check that we have, next slide please, is ID service providers. Now, these have been allowed as an acceptable proof of a right to work for British and Irish nationals only since April 2022. And this is just where you're hiring a commercial third party to provide the checks for you. And in this case, you're obtaining the output report that's been done by the company. You're going to do your due diligence. So you're going to check to make sure that that check was done correctly. And then you're going to retain a copy of that on the file. Now, if you're asking your ID service providers to conduct these checks on foreign nationals, then you're never acquiring a statutory excuse, because only British and Irish nationals are acceptable under this particular route. You are still liable for any civil penalties or any if they've done it incorrectly. So it is making sure that they've done it correctly. Our next poll, if you please, is: can a right to work check be done by a video call? Let's see what you think. Just give you another moment to think about it. Okay, if we could see the results of that, please. Brilliant. So it's a half and half actually there. Yes, you can conduct a right to work check by video call. If you're conducting a manual right to work check, you have to be in physical possession of the document. So they can post you their passport, but you can conduct the check by a Teams call if you want. That's allowed. If it's an online check, that can be done by a Teams call. Of course, there's no physical document that you're checking because you're going onto the gov.uk website. So you can conduct those checks online as long as you're in possession of the physical document for a manual right to work check. You may recall that there was adjusted checks that they used to allow that ended in 2022. You don't have to go back and redo those checks, but you are not allowed to do those adjusted checks where everything was done wholly online and you didn't have the physical document in your possession. Next slide, please. Now, when you're conducting your checks, you want to make sure that the person that's presenting themselves is the person on the documentation. So you're going to check the photograph, you're going to check the documentation, such as a name, the date of birth. And if it's needed, you're going to have to get further evidence to prove why it's different than what they're telling you. If you've got Bob in front of you and it says his name is Frank, then you need some other document to prove that change of name, like a marriage certificate or a deed poll. If you need to check that the documents are genuine, you're not expected to be experts on fraudulent documentation, but the Home Office have given us some helpful guidance and links to archives where you can find travel and identity documents for all the countries, and just so you can satisfy yourself that this does appear to be a genuine document if ever in doubt. If it's reasonably apparent that the person in front of you is not the person in the documents you're checking, then you will not acquire a statutory excuse. And an example I've got of this was a client of mine received the BRP, and then they did an online check, and the photograph in the online check and the BRP were both two different photographs to the person that was in front of them. One photograph looked like a 40-year-old man, the other looked like a 12-year-old, and the person in front of him was clearly a 30-year-old man. And they had some serious doubts that this person was the person in the documentation, so they didn't hire them, that it was too much of a risk to the business. So you're checking to make sure that these are the correct documents for the person that's in front of you. Next slide, please. You're also checking the conditions. So as I said before with illegal working, it's not just enough that they have the right to work. They have to have the right to work in the job that you are offering them. And most immigration routes have conditions on a right to work. The ones that you're going to come across most frequently are international students and skilled workers. Students have very restricted hours. The purpose of their visa is to study, not to work. So if they do have a right to work at all, it'll only be for either 10 or 20 hours per week during term time. They also are not allowed to work in a full-time permanent contract. They can work full-time outside of term time, but they cannot work in a permanent contract. That's a solid no. So if you are putting someone in a permanent contract with a student visa, they are breaching their right to work conditions. They are illegally working. You might come across somebody who's got a skilled worker visa because they're working for another business. Skilled workers can conduct supplementary employment, but they're very restricted as to what additional work they can do. They can only work an additional 20 hours, and the jobs that they do have to be either the job that they're already working for their sponsor or a job that's on the shortage occupation list. So if you've got a person in front of you that's being sponsored as an engineer, they cannot come to work for you as a quality assurance technologist. That's not the same role. They would be illegally working. And that's one of your tricky situations that you're going to come across, because you're going to get a lot of people that are here wanting to work for you, and they seem perfectly qualified to do the job, but their work conditions are very, very strict. Okay. If you get anybody in the UK that's providing you with a British passport, an Irish passport, or somebody with indefinite leave to remain, then they've got a permanent right to work in the UK. You don't need to worry about conditions. That's a one and done. You'll get a continuous statutory excuse for them. And another one of the tricky situations are British passports. It's not maybe so widely known, but there are 6 types of British nationality in the UK. And only British citizens have an unrestricted and permanent right to work in the UK. So if you've got somebody that's presenting what looks like a British passport, but if you look inside, it says British overseas citizen, then you'll need another document for a proof to right to work, because they don't have an automatic right to work in the UK. Those aren't too common, I think. You might get British overseas territory citizens. Those are people from Hong Kong. But you don't come across too many British subjects. I think there are only like a few hundred anyways. Next slide, please. And the final check is the employer's checking service. And as I said before, this is a kind of check that straddles a manual check and an online check. And the reason being is some of the documents that you'll obtain for a manual check require that you obtain an employer's checking service check as well, such as a certificate of application from somebody who's submitted an application under the EU settlement scheme. That certificate of application on its own is not enough to prove a right to work. You have to go to the employer's checking service as well. This is a different service to the online checks. I've got the link there as well. You're going to fill out a small form, and within 5 working days, the Home Office will come back to you with a decision. It should be a positive verification notice, but you could also receive a negative or indeterminate verification notice. The Home Office state that you can only accept a positive verification notice as a proof of a right to work. It's worth noting that some people may have applications in the system. They've submitted an application before their visa expired, and so they can't provide you with a document to prove the right to work, or they can't give you a share code. And that's fine because they might still have the right to work. There's something called Section 3C leave, and it's just the relevant section of the Immigration Act. And what that means is if somebody's made an application before their visa expires, then their visa is automatically extended if the decision hasn't been made on the application when their visa expires. So the conditions of their old visa continue until that decision is made, or in the event of refusal, until their appeal rights are exhausted. So you'll get these situations quite commonly, actually, when you've got foreign workers who have applications outstanding. Next slide, please. This is one of our other tricky situations, is 2B transfers. If you've got people that are being transferred to your business as you've acquired another business, you acquire the statutory excuse from that previous business, but only if they've done it correctly, because you will also take on the liability if they did it incorrectly. And so for this reason, the Home Office have given us a 60-day grace period to conduct new checks. That 60 days starts from the date of the transfer. It can be, if you've got quite a lot of people that are being transferred to your business, it can be impractical to conduct these checks. But as you'll see later on, there might be some really large risks to you if you don't conduct these checks. So it's maybe taking the risk if you feel that it's necessary. But I would always advise you to conduct your fresh right to work check so that you can be absolutely satisfied that that person has got the right to work. We're going to do the next poll. And that is just, what is the correct action to take if a 2B worker does not provide you with evidence of the right to work? And we'll see if this one will make you think a little bit. It's whether you want to terminate immediately, suspend and investigate, or rely on the statutory excuse from the seller. And I'll give you a bit more moments to think about this one. Okay, last couple of seconds. Okay, can we see the results, please? Okay. Oh, well, most of you put suspend and investigate, and then one put terminate. This was actually a bit of a tricky question. And the reason being is that you could have done any of those, and it really depended on the person that wasn't providing it. So in the case of what I would recommend in these cases is that you first look to see what evidence of right to work you have on that was done by the seller. And if it's somebody that's got a British passport or somebody that has indefinite leave to remain, then the risk of civil penalty, the risk that they're a legal worker, is quite low, I would have said. And you could have relied on the statutory excuse from the seller. If it was somebody that had a time limit on their stay, then you could have suspended and investigate. But immigration law is quite black and white, because suspension won't protect you from a civil penalty if it turns out that they were an illegal worker. But also terminating illegally or just terminating immediately, you would have to undergo investigations to make sure that you were falling foul of unfair dismissal claims. So it would depend on what evidence you already had to hand and whether any investigations that you've made. So Tricky question. Sorry about that. Next slide, please. Now, you might ask yourself, how is the Home Office going to know that we've hired an illegal worker? These are private documents that you have, they don't instantly have access to these information. So how are they going to know? Well, if you are lucky enough to have a sponsor license, then you know that they are going to audit you. It is something that they would do for every sponsor license holder, and right to work documentation is one of the first things they're going to ask. Also, the Home Office have got this whole government approach to tackling illegal working. And what that means is that all the agencies and departments in the government coordinate with one another to effectively detect right to work through the sharing of intelligence. And in practice, what that means is that the Home Office are contacting HMRC and saying, here's a list of national insurance numbers that we know of people who don't have a right to work. Tell me what you've got. And HMRC are going to say, oh, well, we found these people who are on this PAYE roles. They're working for this company illegally. And then you can absolutely guarantee that they're going to come in and have a chat with you. There are other ways as well that they find evidence, if they're working in immigration raids or in other types of intelligence, they might find evidence of a right to work, conducting a raid on a home or a business, and they find your pay slip that was issued to somebody who didn't have a right to work, or a contract of employment. It's really easy to find those. We all know that the food sector does have a high number of migrant workers. Some areas of the food sector are heavily reliant on migrant workers, and the Home Office know this. They also know that the Home Office also know that criminals know this. And so criminals and criminal gangs, traffickers, they're putting their victims into roles within the food sector, as we saw with Sainsbury's. So the Home Office are looking at your sector. They are trying to detect illegal working. So if you're asking how do they know, they're going to know. And those are some of the ways they can know. Next slide, please. Now, if they find that you have been hiring an illegal worker, then you'll be facing a civil penalty. Now, as of today's date, the maximum penalty is £20,000 per illegal worker. But from the 13th of February, that's tripling to £60,000 per illegal worker. And already we've seen the changes to the guidance. They're already published on the gov.uk website, so if you want to see that. If you might look at this and go, oh, £60,000 isn't too much. We could easily absorb that kind of a fine. But that's per illegal worker. And, we're not a company that only has one or two employees. We're a company that has hundreds, if not thousands, of employees. So if they're going to detect one, they might detect more. And some of you might recall back in 2016, there was a dawn raid by immigration officers on Greencore, who, if you don't know, is the UK's biggest sandwich maker. And that resulted in 32 workers being arrested from just that raid. Now, I don't know how much I did look up to see if I could find how much they were fined, but I couldn't find how much civil penalty they had, if at all. But if we're going off 32 workers, then in 2016, they were looking at a maximum fine of £640,000, which is a lot. And if we were to put that, if they were checked later this year, then that fine increases to £1.9 million for 32 workers. So that's not a small amount of money. And I don't know of any company that could just easily absorb £1.9 million fine. So that's, it can get really expensive, especially in this sector. If you do receive a civil penalty from the Home Office, then you're also going to be named and shamed by them. They publish quarterly reports of those companies that have been fined, and they'll write your name, your address, and the amount of fine that you've received. And your local newspapers, they look for these lists for any company that's within their area, and they report on them. So you're going to have, your Bolton Gazette or, your Norwich Times, they're going to be reporting about your company and the massive amount of fine that you've received. And that's reputational damage. Again, we talk about Sainsbury's, even though they weren't responsible for that, it was their name in the news that was connected to this criminal gang and to illegal working. Of course, if you have your statutory excuse on every one of those workers, then you don't have to worry about any of this because the Home Office will not issue you a civil penalty. They'll just say that they're not taking any further action. And you've done your job to protect the business from this, from the fine, the operational damage, and reputational damage. Next slide, please. There are ways, though, to decrease that breach. That £60,000 is the maximum per legal worker. So what they'll do is they'll tell you if they're going to fine you. They'll determine whether you're liable for it, and that just means that you haven't got your statutory excuse. They're going to determine your level of breach. So have you breached in the last 3 years? If you haven't, that's going to reduce the amount that they'll charge you. And then there are other different mitigating circumstances. Do you have an effective right to work practice in place? Did you report that you had a suspicion of legal working? Were you cooperative with the Home Office? And so the maximum amount is £60,000 per legal worker, but that drops down to £35,000 per legal worker if you conducted all these things to mitigate and reduce the penalty. But if we go back to the green core, the 32 workers, that's still a fine of £1.1 million. So it's still an expensive, costly exercise. Now, next slide, please. In the most serious of situations, and I don't think this is anybody here that's on this call, but in the most serious, if you are continuously hiring illegal workers, you're continuously being found out, then the Home Office is going to take much more drastic measures because you are now a risk to immigration control. And it will be things like shutting down the business, disqualifying the directors, seizing assets. You can absolutely ensure that this is the kind of thing that the Home Office will report on. They love telling the public about how tough and strong they are being on immigration. And so if they say that they've shut you down, your name is going to be all over the business. But these are the most serious of circumstances. I don't think that anybody here would suffer these, but it's worth bearing in mind because if you continuously get caught employing illegal workers, then this is something that you might face. And it's just the final poll, just to see if you've been paying any attention. Are right to work checks required for an employee who's previously worked for the company, left the company, and then has come back and recommenced employment with you? Tell me what you reckon. Let's give you a couple more minutes, a couple moments. Can we see the results on that? Well, so most of you got that right. Yes, you have to conduct new right to work checks. The reason being is that when that person left your employment, that statutory excuse ended. And so you would need to reacquire a new statutory excuse in order to protect the business in case that, bear in mind as well that, things can change. A person's life can change quite drastically in that space of time. And they may have lost the right to work. So don't make assumptions. Again, it's that whole point about not discriminating. Don't make assumptions. Always check. Always protect the business from the risk of illegal working. And then next slide, please. It's the final thing I just want to talk about really is balancing the risk. Immigration law, as I've mentioned previously, is very black and white. You cannot hire illegal workers. The Home Office guidance states that you would have to terminate employment. It's black and white. But there are other legal considerations that as employers we have to bear in mind, like employment law, unfair dismissal, discrimination. So when you are looking at somebody who doesn't have a right to work, or a worker that's with you that may have lost the right to work, you need to assess whether the risk balances in favor of immigration law or an employment law. Bear in mind that with immigration law, the risk is only if that person doesn't have a right to work. So they might have a right to work, but they can't prove it. And you might conduct things like an employer's checking service check, and it might come back negative, but that might still be wrong. The Home Office does get it wrong sometimes. So, if your employee has been with you for over 2 years, so they've got full employment rights, you've got to balance the risk of a civil penalty against the risk of an unfair dismissal or the cost of defending an employment tribunal claim. I'm going to give you a couple of examples. I had one employer had done a follow-up check on their employee because their visa was due to expire. The employer checking service came back positive. That was fine. But no, they didn't get a decision on their application within that 6 months. So they conducted a second employer's checking service check. And that one came back negative. Now they suspended the person and they ran a full investigation with the risk of terminating employment. And it turns out that the employee had submitted a right of appeal. So his Section 3C leave was continuing. And for whatever reason, the Home Office didn't have that in their records yet. And in that case, the worker did I think was quite extreme, but his solicitor had sued the Home Office for this under judicial review, and the Home Office conceded that they were wrong. And so my client continued, they didn't have that statutory excuse anymore because they'd received a negative verification notice. But they had seen other evidence to indicate that this person did have a continuing right to work. So they balanced the risk in that case, and they chose to go in favor of the worker remaining because they'd seen other evidence, even though that statutory excuse was lost. Another situation I very recently saw was this worker follow-up check was missed. When the person was employed, the follow-up check wasn't put into the diary. And so it was 6 months later after the person's visa expired that they realized that his visa had expired. They made some initial queries with him. And the only information that the worker had given is that he couldn't afford he was saving up money for a solicitor. That didn't indicate whether or not he had a right to work. So they kept him in employment while they conducted further investigations. But what they ended up doing is pulling in the worker in for a meeting to discuss what was going on. And during that meeting, he admitted that he simply couldn't afford the Home Office fees. And so he never made his application. He had become an overstayer, and he didn't have the right to work anymore. And it was at that meeting that they both agreed that employment would be terminated immediately. The risk in that case was weighed heavily in favor of the immigration civil penalty because he admitted he didn't have a right to work and he couldn't provide any evidence of it. My client was really upset about that situation because had they caught that right to work check, they, could have chased him up before his visa expired. He could have explained that he couldn't afford the fees at that time and they would have offered him a loan. He was a worker that they really wanted to keep and they were really sorry to see him go. So it's just that balancing the risk and just knowing what's in favor, and everybody that you're going to be assessing is going to be completely different, and all the circumstances are going to be subjective. So it's just keeping that in mind. Now I'm now going to just go to Q&As, questions if you've got any. Oh, I see a couple here actually. Okay. Ruth, what can you please explain the issues with voluntary workers and right to work? What's the definition of a voluntary worker? So a voluntary worker is somebody who has an obligation to work and who you have an obligation to provide work. As a volunteer, it's just somebody who's doesn't have that obligation. And so in that case, a voluntary worker, you have to check that they've got a right to work because of that employment, even though there's no formal employment relationship, because of that duty, that obligation on both sides, it does create that kind of a relationship between you two, and so you have to check those right to works. Nicola, if you have an employee who had a right to work through a visa, but this expires during their employment, what is the legal stance on the employer then having a duty to sponsor them or not? You don't have any duty to sponsor a worker if you don't want to. But you do need to bear in mind, and I would strongly recommend that you seek some advice from your employment experts, just because you want to make sure that if you've got a policy in place for this point, you want to, again, it's making sure that you're not discriminating against somebody. So while there's no legal duty to sponsor somebody, you just want to make sure that you are applying the same policy for everybody to make sure that it's not discriminatory. Any other questions? Oh, how long do we need to keep our right to work documents? You have to keep them for up to 2 years after the person has left the business. and that's part of right to work legislation. You might have to keep them longer if there's another area of law that requires that you keep them longer, but for right to work legislation, it's 2 years past their employment ending. Yeah. Are there any more? No? Simon, do you have any questions?
No, it was all self-explanatory to me, and I hope it was for everyone else. I'm sure it was.
So if immigration@freeths.co.uk, that's how you can get a hold of me if you do any questions. As I said, I will be coming back to a couple of you with questions that you sent in when you registered. But otherwise, I hope that this was informative, and I really want to thank you very much for joining us.